Welcome to the Center Regional Planning Agency's training on zoning ordinances and their administration. This course was created as part of a comprehensive training program to provide municipal planning commissioners in the Center region with localized planning-related education opportunities. My name is Mark Bokel, and I'm a senior planner with the Center Regional Planning Agency, where I conduct regional planning for the 6 Center Region municipalities and serve as a local planner for Harris Township. I will be your presenter for this course. While this course and supplemental materials are available online, CRPA staff can also provide this course as a workshop on request. This course is intended to provide an overview of zoning regulations, their purposes and limitations, and administration. Planning commissioners will also learn about different approaches to creating zoning regulations and common legal challenges. Before we begin discussing the actual course material, take a moment to examine the pictures of the various land uses shown on this slide. Which of these uses would you choose to have as your neighbor? What would be the benefits and drawbacks? Would there be any negative impacts to you as a property owner? While this is a simplistic illustration to emphasize the purposes and benefits of zoning, it helps to reinforce some of the key benefits of land use regulations. So what is zoning? As was illustrated in the previous slide, certain land uses interact negatively with other uses, so it makes sense to keep them apart where possible. We do this through zoning regulations. Simply put, zoning ordinances are laws that regulate the use of land. They specify the land uses that can be established on private property and the criteria that need to be met to conduct those uses. Keep in mind that zoning laws are not the same as subdivision and land development regulations, which help guide the division of land into multiple properties or the development of land into a particular use. While zoning and SALDO ordinances are often utilized at the same time, they are vastly different both from a purpose perspective as well as the legislation that defines how and what they can be used for. Ultimately, zoning regulations are meant to protect and promote public health, safety, morals, and general welfare of citizens. This is a broad statement that can be interpreted in many ways, but it is important to keep in mind that zoning regulations must advance a public purpose that is rooted in these criteria. There are many benefits to zoning ordinances, some of which are easy to measure and identify, and others of which are more subtle. For starters, zoning should promote the best use of land in question. In other words, in conjunction with community planning, zoning regulations should promote a use of the property that suits not only its physical characteristics, but also its location within the broader context of the community. Zoning also creates predictability and helps to protect property values in neighborhoods. Imagine that you lived in a nice residential neighborhood and a vacant lot down the street was suddenly developed as a landfill. While this example seems far-fetched, how would this affect the value of your property, the desirability of your neighborhood, and the health of you and your neighbors? Zoning helps to ensure that the community has a system to allocate uses in a way that protects residents and promotes a high quality of life. Zoning can also help to protect sensitive areas and environmental features, such as waterways, steep slopes, and other natural environments. Zoning helps to prevent overcrowding, ensuring that individuals have access to light and air. While this may seem like a common sense purpose and benefit, urbanized areas were not always developed with these qualities in mind. Zoning also helps to separate land uses as needed. Zoning ordinances tend to allow similar uses to be located in close proximity to one another, but separate uses that are deemed incompatible. Houston, Texas is famous, at least in the planning community, for being the only major American city not to have zoning ordinances. While Houston doesn't have zoning, they do have a plethora of land use regulations, but the lack of zoning for land uses results in a mixture of uses that would likely be avoided in other communities. So where did zoning come from exactly? Zoning regulations are a fairly modern regulatory tool and have only been used by communities for a little over 100 years. Historically, if you had an issue with a neighboring property owner or business, you had to take it up with the local courts through a lawsuit. By the early 20th century, several factors propelled the development of zoning ordinances in major cities. While some communities had some basic regulations regarding certain uses since the 19th century, zoning was a method of handling nuisances and uses in a more systematic method. In 1916, New York City adopted the nation's first comprehensive zoning regulations. While some other communities had some level of zoning regulations by this time, New York City is credited with being the first city to adopt a comprehensive ordinance. New York City adopted this zoning in large part due to a new structure on 120 Broadway known as the Equitable Building. This building was almost 540 feet tall and cast a 7-acre shadow on surrounding property. The age of many taller structures in New York City can be determined based upon the style of construction, which changed immensely following the 1916 ordinance being adopted. Since zoning was more or less a 20th century construct, it did not have a long-standing history either in the nation or throughout the world. In the mid-1920s, the constitutionality of zoning in the village of Euclid, Ohio was challenged by the Ambler Realty Company. In the 1920s, Euclid adopted a zoning ordinance to prohibit the industrial uses in nearby Cleveland from overtaking the community. Ambler Realty owned a 68-acre tract in Euclid. Ambler Realty sued the village, arguing that the zoning ordinance had substantially reduced the value of the land by limiting its use, amounting to a deprivation of Ambler's liberty and property without due process. In 1926, the U.S. Supreme Court upheld Euclid's zoning ordinance as constitutional and a legitimate use of the community's policing powers. Basically, the same authority that allows a speeding driver to be pulled over also allows a community to enact and enforce zoning regulations. Following the Euclid v. Ambler case, many communities throughout the United States adopted zoning regulations. While zoning was found to be constitutional in 1926, there have been many challenges since that time. Zoning is constitutional, but only if it has a legitimate public purpose and is not violating a person's right to due process. There have been numerous challenges to the constitutionality of specific zoning provisions, some of which have been upheld and others of which have been overturned. As noted in the previous slide, zoning ordinances must serve a legitimate public purpose. They also need to be proportional and have a rational nexus to what they are trying to accomplish. For example, a municipality cannot create regulations that are for a purpose that they cannot achieve. They must also be consistent. An example would be having regulations for cellular telephone towers that are vastly different from radio towers. Unless there is a legitimate reason to restrict the height of one tower more harshly than another, this type of ordinance could be deemed unconstitutional. It's important to think about these issues whenever municipal regulations are proposed to ensure they can withstand a legal challenge. As was just discussed, zoning provides a number of benefits to the community that would be difficult to achieve without these regulations. But what is the relationship between planning and zoning? Planning commissioners spend a lot of time working with zoning ordinances, either through their administration or through the adoption and amendment of ordinances, but zoning is not planning. Zoning is, however, a primary tool that is used to implement a plan. If you have a plan to build a house, you need tools and materials to do that. Zoning is one of the tools that municipalities can use to make their plans become a reality. Zoning regulations must be based on solid planning in order to be effective. Imagine trying to build a house without a plan. You might do okay for a while, but as things get more complicated, it will be hard and costly to undo what you already did. Sticking to a plan is not only important because it ensures that your zoning ordinances are guided by something that has been approved and vetted by the community, but zoning based on solid planning can help to thwart legal challenges. If something has been planned for in an appropriate manner and was adopted as part of an official plan, the courts can see that the zoning decisions were related to a public purpose that was previously specified and planned for. There are numerous types of zoning ordinances in existence, and each follow a slightly different approach to regulating the use of land. For the sake of brevity, this course will only provide an overview of the zoning types commonly found in the United States. The first and arguably the most common type of zoning is Euclidean, which is named after the village of Euclid, Ohio. Euclidean zoning regulates uses by grouping similar land uses together. Each of the municipalities in the center region utilizes some form of Euclidean zoning as the basis for their regulations. Euclidean zoning is an efficient way of defining what uses can be permitted in different geographic areas. Incentive zoning is similar to Euclidean zoning, except that it provides additional benefits that can be obtained when a development exceeds the base level of regulation. For example, base regulations may permit the development of a 2-story office building, but additional floors could be added in exchange for things like affordable housing, parkland, or transit amenities. Several center region municipalities have included incentive benefits within their districts, such as the Borough of State College. Incentive zoning tends to be more effective in densely urbanized areas since land is more expensive and less available. Form-based zoning is a modern approach to zoning that attempts to accomplish an urbanized way of development. Rather than focusing on the use of structures like Euclidean zoning does, form-based zoning focuses on the form of development and its relationship to the public realm. Form-based codes promote a mix of uses and have been adopted in many communities throughout the country. Many communities tend to incorporate form-based elements into their Euclidean zoning ordinances rather than abandoning the traditional land use-based system. This can help ensure that form of development is maintained while land uses are controlled. In Pennsylvania, municipalities are enabled by the Municipalities Planning Code, known as the MPC, to enact zoning ordinances. This section of the course will provide details on the MPC's contents and what that means for municipalities. Specifically, the MPC states that municipalities can utilize zoning ordinances to implement comprehensive plans, emphasizing the planning-zoning relationship. The MPC also permits counties to enact zoning ordinances, and in some rural areas, municipalities may rely entirely on a county's zoning ordinance. There are also some municipalities that choose not to enact zoning at all. Once a municipality enacts a zoning ordinance, it automatically supersedes any county ordinance, ensuring that land use controls ultimately lie at the local level. Once zoning is enacted, no property or land can remain unzoned. All 6 of the Center Region municipalities have adopted zoning ordinances. In regards to the purposes of zoning, the MPC provides a long list of what zoning can be used for, what it can and cannot do, as well as requirements for what zoning ordinances must do. All of these requirements are relatively general, allowing the municipalities to tailor their zoning ordinances in a way that best fits their municipality and municipal goals in regards to growth and development. One of the purposes of zoning outlined in the MPC is that it can be used to promote public health, safety, morals, and general welfare. The MPC goes on to specify that zoning can be used to ensure that future growth can be accommodated, that access to goods and services can be provided, that residents have access to a reliable water supply, that natural resources are preserved, as well as a number of other specific criteria. Zoning can be used to prevent the overcrowding of land, blight, danger, and congestion in travel and transportation, loss of health, life, or property from fire, flood, panic, or other dangers. For example, many municipalities will have restrictions on development in the floodplain. Blight is commonly addressed in zoning ordinances as a means of maintaining property values and avoiding rodents and other issues related to blighted properties. Zoning can be utilized to preserve prime agricultural and farmlands. This section of the MPC is often cited by municipalities that are revising their agricultural zoning regulations to require larger lots. In many legal cases related to downzoning claims, the courts have relied upon this section of the MPC as the nexus between large lot size requirements and agricultural preservation. Zoning should be used to provide for a variety of housing types and accommodate overall growth in the community. There are no specific requirements regarding the variety of housing types, but generally municipalities should have an idea of their growth trends, whether they are positive or negative, and the general implications of that. In some communities that are facing population declines or having an influx of a particular demographic such as senior citizens, zoning ordinances can be used to address specific housing needs as well as blight from vacant homes. While the MPC provides general purposes, it also gives specifics on what zoning can do. The MPC states that zoning can permit, prohibit, regulate, restrict, and determine the use of land, water courses, and bodies of water. Zoning can regulate structures such as their height, location, scale, etc. It can also regulate their condition, ensuring that they are maintained. In addition to regulating structures in regards to form, zoning can also specify how much of a property can be covered with buildings, impervious surfaces, etc. Zoning can be used to regulate population density and general intensity of land uses, such as the difference between an R1 and an R4 zone. Finally, zoning can be used to protect and preserve natural and historic resources, and once again, prime agricultural land and farming activities. The MPC includes even more limitations and requirements, some of which are redundant with what has been mentioned previously. Zoning ordinances cannot restrict the display of religious symbols on property being used for religious purposes. Throughout the United States, there have been numerous zoning challenges related to religious uses. Most recently, the Supreme Court ruled in the Reed v. Town of Gilbert case, where the town had restricted a church's right to advertise for services based upon the content of their sign. Municipalities cannot use zoning to unreasonably restrict forestry activities. This right to timber law does not stop municipalities from enacting regulations to ensure that best management practices are followed, but timbering cannot be outlawed in any municipality. Once again, the MPC mentions prime agricultural land by stating that zoning ordinances shall protect such land and can promote agricultural security areas. It doesn't state how this can be accomplished, only that municipalities must address this in their zoning ordinances. The MPC states that zoning ordinances shall protect natural and historic resources. Zoning ordinances are not only required to protect prime ag land, but are also required to encourage the continuity and viability of agricultural operations. Several Center Region municipalities have reviewed and considered ordinance amendments to permit commercial agricultural uses such as farm cafes that were recently permitted in Ferguson Township. Adapting zoning ordinances to keep up with current trends and demands is necessary to help improve the long-term viability of agriculture. Zoning ordinances shall also provide for reasonable development of minerals in every municipality. The key word here is reasonable, which doesn't imply that mineral development must be allowed to happen everywhere. The MPC also provides specific benefits and opportunities to municipalities that participate in a multi-municipal comprehensive plan, such as those in the Center Region. One such benefit is that municipalities that participate in such a plan are permitted to enact a joint municipal zoning ordinance. This has failed to gain traction in the Center Region, but other municipalities in Pennsylvania have enacted joint zoning. One of the benefits is that there is greater consistency across municipal boundaries. However, some municipalities may feel a loss of autonomy. For municipalities that participate in a multi-municipal plan but do not have joint zoning, the MPC still provides benefits related to legal challenges. Specifically, municipalities that participate in a multi-municipal plan are permitted to share land uses across municipal boundaries. All municipalities are required by the MPC to provide for all land uses within their jurisdictions. So every municipality must permit every use from residential homes to adult businesses to landfills. But that requirement applies to the entire planning area when a multi-municipal plan is adopted. This protects municipalities from exclusionary zoning and fair share challenges and also allows for the establishment of better land use patterns. This benefit can be strengthened by adopting an implementation agreement that formally identifies how land uses will be shared throughout the planning area. In the Center Region, Patton Township and College Township participate in an implementation agreement where they share industrial and multifamily land uses. The next section of this course delves briefly into zoning terminology and format. The MPC does not provide comprehensive terminology, but most municipal ordinances include a definition section. This part of the course is meant to explain the basic construct of a zoning ordinance. Municipalities that have zoning are divided into districts, each of which have different land uses and standards. These districts are identified on a zoning map. Zoning districts can permit uses either outright, by condition, or as special exceptions. Permitted uses are those that can be established without any special approvals. A conditional use requires a hearing and will generally have conditions attached to its approval. Conditional uses are typically those that may have greater impacts on the community but can be mitigated through extra regulation. Special exceptions are similar to conditional uses except that they are approved by the zoning hearing board. The location of uses are regulated with setbacks, which establish the distance that the use must be from a property line. This is done to prevent crowding of uses, minimize impacts, and ensure fire, safety, and access. Zoning regulations often address the size of uses, either with maximum coverage limitations or with floor area ratios. FARs are more common in urbanized areas. If a zone has an FAR of 1, that means that the floor area cannot exceed the size of the lot, regardless of its configuration. In addition to regulating uses, zoning ordinances will also include standards for other aspects of land use. Some uses may have specific regulations, and there are often general standards that apply to all uses. Some of those general standards can include things such as outdoor lighting and signage. There are a variety of other supplemental regulations that vary by municipality. Another issue commonly addressed in municipal zoning and in the MPC are nonconformities. There can be nonconforming uses, lots, structures, as well as nonconformities related to other aspects of a zoning ordinance. The term nonconformity is often referred to as grandfathered. Basically, if a use or structure was legally established prior to the existing zoning ordinance being in effect, it is typically considered nonconforming. A nonconformity is allowed to remain as it exists but cannot be expanded or abandoned. Some municipal ordinances may allow nonconforming structures to be extended so long as the degree of nonconformity is not increased. While planning commissioners will typically work with zoning ordinances through their development, adoption, and amendments, they also play a role in their administration. Zoning ordinances are administered in several ways, one of which is during the land development review process. When a land development plan is submitted, municipal zoning ordinances must be complied with in order to receive approval. While planning staff will often provide the first review of a plan, planning commissioners should pay close attention to review comments not only to determine if compliance will be achieved, but also to identify deficiencies in the existing code. If the development will create negative impacts or unforeseen circumstances that are contrary to the community development objectives, zoning ordinance amendments can be proposed to address these issues in future developments. Whenever actual construction is proposed, a zoning permit is typically obtained. Zoning permits are normally reviewed by municipal staff, who will identify any deficiencies that need to be corrected. Administration also occurs when a municipality takes enforcement action. Whenever a violation of the zoning ordinance exists on a property, the municipality can administer the code by requiring the violation be corrected. Property owners are able to seek relief from municipal zoning regulations through the variance process. Variance requests are heard by the Zoning Hearing Board as opposed to the Planning Commission. If a variance is granted, future plans should reference the variance and approval date so that any inconsistencies with the zoning ordinance are justified. A variance amounts to permission to violate the zoning ordinance. Unlike waivers to the subdivision and land development regulations, variances can only be granted if the strict criteria outlined in the MPC are complied with. Planning Commission members should be generally aware of variance criteria, since an applicant could seek a variance if the Commission finds that their proposal is not in compliance with the zoning ordinance. While an ordinance amendment is another means of remedying a noncompliance issue, applicants may perceive that a variance is an easy means of resolving an issue. Variances are intentionally difficult to obtain because otherwise the integrity of zoning regulations would be compromised. The MPC defines 5 criteria that are required to receive a variance. These criteria are not unique to Pennsylvania, as most statewide enabling legislation will provide some criteria for zoning variances. The criteria are as follows. The property has unique physical circumstances or conditions. The property cannot be developed without a variance. The hardship has not been created by the appellant. The variance will not alter the character of the neighborhood or district, and the variance will represent the minimum variance that would afford relief. The key is that all of these criteria must be met in order to have a variance granted. So if an applicant only meets 4 of the 5 criteria, a variance should not be granted. There are several types of variances that can be requested, the most common of which is dimensional variance. Dimensional variances relate to the size of the property, setbacks, coverages, etc. A de minimis variance is a variance that deviates minimally from the ordinance. For example, a person requesting a variance of 6 inches may be given a de minimis variance because for the most part the ordinance is still being preserved. A less common type of variance is a use variance. These are rarely granted as they constitute spot zoning. A use variance should only be granted if the property cannot be used for any other permitted use without the variance being granted. Another method of seeking relief from a zoning ordinance is to request a curative amendment. Planning commissioners should be aware of what a curative amendment is and how this type of relief can be prevented. Curative amendments are used to challenge the validity of a zoning ordinance and are normally requested when an applicant believes that the ordinance is exclusionary. For example, if a company wants to establish a landfill on property in the municipality, but the municipality doesn't permit landfills anywhere, they could file a curative amendment. What they're asking is that the municipality cure or fix the ordinance in order to make it whole, since the MPC requires all land uses to be accommodated. The municipality can accept, revise, or reject the amendment. They don't need to give the applicant exactly what they want, but they would need to fix the ordinance and if it is exclusionary or possibly risk additional legal action. The key to avoiding curative amendments is to review municipal ordinances to ensure that all uses are provided for and can be developed. Even if a use is permitted, an ordinance could still be deemed exclusionary if it could not be developed due to supplemental regulations. In conclusion, planning commissioners should strive to have a good understanding of their municipal zoning ordinance and a general understanding of how the ordinance is administered. Some key takeaways from this course include that zoning is the primary tool used to implement the comprehensive plan. This means that the Planning Commission should regularly refer to their plan whenever amending zoning regulations. Understanding and reinforcing this link is key, and something that Planning Commission members should do whenever providing findings of fact when recommending zoning amendments. Zoning ordinances should only be adopted if they promote a legitimate public purpose. So whenever crafting new zoning regulations, planning commissions should question the purpose of the regulation, if it is legitimate, and whether or not the proposed regulations actually do what is intended. Planning Commission members should be aware of different zoning models and consider utilizing different zoning approaches when the situation calls for it. Planning Commissions play an important role in administration of zoning regulations, in particular through plan reviews. And zoning relief can be sought, but it may not always be granted. These options exist nonetheless. That concludes this online PowerPoint presentation regarding zoning ordinances and their administration. For more information on planning in the Center region, please visit our website at www.crcog.net/planning. Thank you.